So this is now the part 2 of our discussion of Article 248. So in this video, what we are going to discuss are now the qualifying circumstances. So among all the qualifying circumstances, ang favorite sa bar exams or yung mabentang-mabenta talaga sa bar exams is your treachery. Kaya we will discuss it in detail. So let's start our discussion to these two requirements. Ano ang sabi ng Supreme Court? There are two requirements in order that treachery may be appreciated. So what are these? Number one, the victim must be in no position to defend himself or herself when attacked. Number two, the assailant must consciously and deliberately adapt the method, the means, the form of one's attack against the victim. Yung number one requirement is madali lang siyang intindihin. But how about the number two requirement? Let's explain further. Ano ang sinasabi ng Supreme Court dyan? According to jurisprudence, sabi doon that the accused must make some preparation to kill the victim in such a way that he or she ensures the commission of the crime or in such a way that it would be impossible or at the least difficult for the victim to retaliate or defend himself or herself. Ano pa ang sabi ng Supreme Court? The mode of attack must be thought of by the offender and must not merely spring from the unpredictable turn of events. Next, according to the Supreme Court, if the attack was not preconceived, it was not deliberately adapted, then there is no treachery to speak of because that would mean that requirement number 2 is not present. Last, if there is no absence or if there is no intention to kill, then treachery cannot be appreciated because again that would negate requirement number 2. There is no deliberate employment of means, methods, and manner of execution if there is no intention to kill. Next, ano ang sabi ng Supreme Court? The existence of treachery should be based on clear and convincing evidence. Bakit? Because treachery cannot be presumed. The evidence must be as conclusive as the fact of the killing itself. In fact, ang sabi nga ng Supreme Court, kagaya ng finding ng guilt of the accused, treachery, if there is doubt as to its existence, then that doubt should be resolved in favor of the accused. So let's read a bar exam question. A and B were both astride the same carabao. So what is the meaning of astride? That one, the one in the picture. So ganyan ang pagsakay nila. Si B is nasa likod ni A. So here comes X. X with the intention to kill A, he aimed his gun at A and fired, inflicting a fatal wound on the chest of A, therefore namatay si A. Hindi pa rin nakontento si X, so he shot A again, but this time the bullet hit and lodged itself in the heart of B, causing also the death of B. So A and B are both dead. Question, what crime or crimes is X guilty of? Answer, as far as A is concerned, X committed the crime of murder. Bakit murder? Because of the presence of qualifying circumstance. What qualifying circumstance is that? That is your treachery. Ano ang sinabi natin? In order for treachery to be appreciated, two requirements must be present. Number one, the victim or A in our example or in our problem must be in no position to defend himself when attacked. So question, was A in a position to defend himself? Answer is no because nakasakay nga siya sa carabao. Number 2, did X, the assailant, consciously and deliberately adapt the means, the methods, or form of one's attack against A? Answer is yes, because by using that gun, we can conclude that X, the accused, the assailant, really made the preparation to kill A. Therefore, in that case, treachery is present. But how about B? What crime is committed by X when it comes to B? Answer is homicide. Homicide. Bakit magkaiba? Kay A, murder. Kay B is homicide. Because when it comes to B, there is no treachery. There is no qualifying circumstance to speak of. Bakit? Because what did we say again? If there is no intention to kill, if there is an absence of intent to kill, therefore there is no treachery. Bakit? Because while you may be able to meet requirement number 1, definitely requirement number 2 is absent. Another bar exam question. Mang Jose here is a septuagenarian. Ano ba yung septuagenarian? He is a person who is between 70 years old and 79 years old. So, he was walking with his 10-year-old grandson in Makati City, but both of them were hit by a speeding van. So, the driver, who is a Chinese mestizo, he stopped his car. Akala mo nung he stopped his car, siya ay tutulong. But what did he do? He reversed his gears and ran over Mang Jose's body anew. And for the third time, he advanced his car forward. Of course, itong si Mang Jose, he suffered multiple fractures and broken ribs, therefore namatay siya. How about the grandson? The grandson survived but he suffered broken legs. So the driver was arrested and charged with murder through reckless imprudence and serious physical injuries through reckless imprudence with respect to the grandson. Question: are the charges correct? Answer is yes. The charges as correct when it comes to Mang Jose. He was charged with murder because of the qualifying circumstance of treachery. Again, what did we say? Sa treachery, there must be 2 requirements that must be present. Number 1, the victim or Mang Jose in our problem must be in no position to defend himself when attacked. Number 2, the driver must consciously and deliberately adapt the methods, the means, or the form of one's attack against the victim. Can we conclude that the driver consciously and deliberately adapt that method? Yes, because ang ginawa pa nga ng driver is he ran over the body of Mang Jose twice. Binack up niya yung van, drive niya forward. Therefore, we can conclude na meron talagang intention on the part of the driver to kill Mang Jose. And that is the reality. Marami tayong mga naririnig na news na may mga drivers na tinutuluyan talaga nila ang kanilang mga nasagasaan. But how about yung serious physical injuries with respect to the grandson? Are the charges correct? That is also correct. Another bar exam question. A here is a 76-year-old woman. So she was brought to the hospital in a coma with slight cerebral hemorrhage. So nilagyan siya ng tube sa kanyang mouth to facilitate yung kanyang paghinga kasi nahihirapan. But here comes B. Who is B? He is a hospital janitor. So he had no business in the emergency room, and for reasons known only to himself, he removed the plaster that holds the tube in place. A doctor saw him and told him to get out of the room. But when the doctor was gone, itong si B bumalik, and this time, ang kanya nang tinanggal is hindi na yung plaster but the tube itself. So the victim A started to bleed in the mouth and convulsed. Only the timely arrival of the nurse prevented the death of A. So A was then transferred to another hospital, but she died the next day because of cardiorespiratory arrest. Question: is B criminally liable? Answer of the UP Law Center is yes. B is liable for murder. Bakit? Because there is treachery. Again, what did we say? Twin requirement ng treachery, dapat maipakita that the victim was in no position to defend himself when attacked. Was A in a position to defend herself when attacked? Hindi, because naka-coma nga. She was in a coma. Number 2, did the assailant consciously and deliberately adapt the methods, the means, or form of one's attack against the victim? What is your answer? Guys, ang pagsagot ng problems like this is mahirap. Hindi mo alam kung tama ang conclusion mo. Kaya, what is my tip? My tip is when you are confronted with problems like this and you are not sure of your answer, then you write the law. Kaya ko in-include talaga dito, dinidiscuss ko pa ulit-ulit yung requirements ng treachery is para kung nahihirapan kayong mag-arrive at a conclusion, just write these 2 requirements, and even if your conclusion is not correct, is wrong, at least your law is correct. Kahit naman yung mga kahit naman yung mga justices, kahit yung mga judges, nagkakamali din sila sa kanilang appreciation of facts. But what is important is your law is correct dahil walang clear-cut rule pagdating sa treachery. Depende yan sa appreciation of facts. Problem like this, malilito ka, nakakalito. Is there treachery involved? Depende sa iyong discussion, depende kung paano mo i-argue. Kaya the best way to approach this kind of problem, lalo na kung hindi ka nakabasa ng jurisprudence, is to attack it and to state the requirements of the law. Next, if you will be confronted with a question where ang napatay or ang pinatay is a child, then the answer is always murder. The killing of children is always murder, qualified by treachery. Bakit? Because minors cannot put up any defense against an assailant. In fact, ang sabi pa nga ng Supreme Court that if you are going to kill a child of tender years, that is murder, even if the manner of attack is not shown. Okay, so to illustrate again, Lina here is a housemaid and yaya ng 1-week-old son ng spouses John and Joanna. So itong si Lina, the yaya, nangutang sa kanyang amo, but the amo is hindi pumayag. So what did she do? In anger, Lina gagged the mouth of the child with stockings, placed him in a box, sealed it with masking tape, and placed the box in the attic. Lina then left the house and asked her friend Feli to demand a 20,000 pesos ransom for the release of the child to be paid within 24 hours. But the parents of the child did not pay. After a couple of days, the father discovered the box in the attic with his child already dead. But according to the autopsy report, the child died barely minutes after the box was sealed. So question, what crime or crimes, if any, did Lina commit? So as far as Lina is concerned, Lina is liable for murder. Bakit murder? Again, because of that qualifying circumstance. And what qualifying circumstance is that? That is treachery. Ano ang sinabi natin? Kung ang napatay or kung yung pinatay is a child, that is always murder, qualified by treachery, because minors cannot put up any defense against an assailant. In fact, ang sabi pa nga ng Supreme Court, if you are going to kill a child of tender years, like in our problem, 1-week-old pa lang siya, the killing of that child of tender years is murder, even if the manner of attack is not shown. But how about Feli? Sino si Feli? Feli is the friend. Is she liable also for murder? Answer is no. Feli is not liable for murder as principal or accomplice. Bakit? Because you cannot derive that there is conspiracy or community of design to commit murder. Ang kanyang intention lang ni Feli pertains only to kidnapping for random. There is no participation The participation of Feli in demanding the ransom for the release of the child is not connected in any manner to murder. That is the reason why she cannot be liable for murder. So we're done with children. Let's go now to the rules about attack from behind and frontal attack. So if you are attacked from behind, can you say that requirement number 1 is present? Answer is yes, because if you are attacked from behind, then you, victim, you are not in a position to defend yourself. But ano ang sinasabi ng Supreme Court? Even if you are attacked from behind, that is not always treachery. Bakit? Because aside from requirement number 1, you have to comply with requirement number 2. Kaya nga, twin requirement. But how about frontal attack? Frontal attack. Does it mean that your requirement number 1 is absent? What did the Supreme Court say? A frontal attack does not necessarily rule out treachery. Bakit? Because if that frontal attack is so sudden and so unexpected that the deceased had no time to prepare for his or her defense, then it is as if that the victim is once again, he is not in a position to defend himself. So for illustration, here is a bar exam question. There are 4 personalities involved here. Si Juan, meron siyang kapatid. He has a brother, the name is Rodolfo. Pedro, on the other hand, is a father. He has a son, si Carling. So itong si Juan and Pedro had a land dispute for a number of years. So itong si Rodolfo, he was attacking Pedro with a bolo from behind. So nung he was about to hit Pedro a second time, dumating si Carling, the son of Pedro, and sabi niya, I will kill you. But what happened? Carling suffered a number of wounds and he died on the spot. How about Pedro? Pedro was in serious condition and he died 5 days later for loss of blood because the blood purchased from Manila, which could have saved him, did not arrive on time. So question, what crime or crimes, if any, did Rodolfo commit? Answer is, as far as Pedro is concerned, Pedro is the father, Rodolfo committed the crime of murder. Murder because there is a qualifying circumstance and that qualifying circumstance is treachery. Again, what did we say? If you will be attacked from behind, even though you are not in a position to defend yourself, make sure that you comply also the requisite number 2. What is requisite number 2? The offender, or Rodolfo in this case, consciously adapted the particular means, the methods or form in attacking Pedro. Since gumamit si Rodolfo ng bolo, and when he used that bolo is when he attacked Pedro from behind, therefore we can say that there is treachery. And when there is treachery, ang crime na commit ni Rodolfo is now moved to murder. But how about Carling, the son? What crime did he commit? Rodolfo is only liable for homicide. Bakit homicide? Because that is the killing of Carling is the result only of a fight, both of them being armed with bolos. Another bar exam question. The accused here, with no intention to kill the victim, he treacherously shot the victim while the victim was turning his back. He aimed at and hit the victim only on the leg, but the victim died because of loss of blood. Question. Can the accused be liable for homicide or murder? Answer is only homicide. Bakit? Because walang qualifying circumstance involved in this problem. You cannot appreciate treachery because treachery, if there is no intent to kill or that intention to kill is absent, that negates requirement number 2. Maaring na-meet mo si requirement number 1, the victim was not in a position to defend himself because When you shot the victim, he was turning his back to him, but did you meet requirement number 2? Sabi ng batas is no. But how about yung sa problem na sinasabi ng problem natin that can the accused be held liable for homicide or murder considering that treachery was clearly involved? How will you answer that question? Ano ang sinasabi palagi ng Supreme Court? Treachery cannot be presumed. It cannot be presumed. There must be evidence that is as conclusive as the fact of killing itself. The finding of the existence of treachery should be based on clear and convincing evidence. This is the reason why the answer here of the UP Law Center is the crime for said death is only homicide and not murder. Take note that abuse of superior strength, employing means to weaken the defense, band in aid of armed men, nighttime, they are absorbed in treachery. Bar exam question. On his way to buy a lotto ticket, here is a policeman who suddenly found himself surrounded by 4 men. One of them wrestled the police officer to the ground and disarmed him, while the other 3 companions were armed with a hunting knife, an ice pick, and a balisong who repeatedly stabbed the policeman. So, syempre, itong si policeman, because of the multiple stab wounds, ay namatay. Question, what crime or crimes were committed? Answer is, they committed the crime of murder. Bakit murder? Because there is a qualifying circumstance. Ano ang qualifying circumstance in our problem? The qualifying circumstance is treachery. Bakit treachery? Meron namang abuse of superior strength because the policeman was surrounded by 4 men. Because treachery absorbed abuse of superior strength. Therefore, your qualifying circumstance is treachery. Take note that the victim in our problem is a policeman. Pag ang victim policeman or any public officer, kailangan alerto kayo ha, because that might be a complex crime, a murder with direct assault. But in our case, can you say that it is murder with direct assault? Answer is no. Bakit? Because there is no indication in our facts that would show that itong 4 men, itong ating mga accused, knew that the victim was a policeman. Or there is no showing in our facts that our policeman was involved or was in the performance of his official duties. Therefore, you cannot say that there is a direct assault. Another bar exam question, yung facts dito is more or less similar sa binasa natin kanina. May difference lang. The only difference is our victim, si Joe, is not a public officer. He is not a policeman. But the same, 4 ang tao na involved, pinagtulungan si victim ng 4 na tao. So question, what was the crime committed by the 4 assailants? Answer is murder. What is your qualifying circumstance? Treachery. Bakit hindi abuse of superior strength? 4 ang tao na involved. Because what did we say again? Treachery absorbs abuse of superior strength. Bakit treachery? Because Joe here, the victim, was rendered defenseless. He has no chance to retaliate. That is the reason why treachery is present. Next, according to the Supreme Court, treachery can also be appreciated in aberratio ictus. When the offender fired at his adversary but missed, the victims also at the time were helpless to defend themselves. Their deaths is therefore murder and not simply homicide because the acts were qualified by treachery. But if the victims did not die, the crime is only physical injuries because the offender had no specific intent to kill the unintended victims. Down to our last slide, here is Roberto. Sino si Roberto? He is a son and he is the general manager of a family corporation. But itong si Roberto is incompetent, unable to control his temper, and frequently quarrels with the employees. So his father finally decided to dismiss him. So itong si Roberto, galit na galit, so he decided to get even. So what did he do? He waited at the exit of the parking lot where his father always passes. So when he saw that the car of his father is approaching, Roberto fired his pistol in the direction of the driver, thinking that the driver was his father. But unknown to him, the victim is was tagahatid. Sino si tagahatid? He is a company messenger. The father instructed the company messenger to drive his car home. Therefore, itong si Roberto surrendered to the authorities. After investigation, the fiscal now filed an information against Roberto for murder. The fiscal alleged that the killing was characterized by treachery as the victim was ambushed. However, the counsel of Roberto insisted that the crime is not murder but only homicide. Question: was the killing characterized by treachery? Answer is yes. Bakit merong treachery? Ang intention lang naman ni Roberto is to kill the father and not the company messenger. Ano ang sabi ng Supreme Court? Treachery may be appreciated in the case of aberratio ictus. Bakit? Because in aberratio ictus, the victim is helpless. He is helpless to defend himself. Their death is not therefore simple homicide but murder because the acts were qualified by treachery. But if itong si tagahatid is hindi namatay but suffered only physical injuries, then the crime now is only physical injuries. Bakit physical injuries lang? Because again, Roberto had no intention to kill tagahatid. His intention is to kill his father. This is also the answer of the UP Law Center.